Hi, this is Dr. Ishita Sharma, and in today's lecture, we are going to discuss the evolution and development of law of torts in England. Even though the same violation may be both a tort and an offence at the same time, a tort differs from a crime in that it is resolved through reimbursement or recompense rather than through punishment or fines. Tort is different from contract violation in that the rights and obligations in a contract are established by consensus of the parties involved and is enforceable against them. Pre-decided damages may be used to compensate for violations of contracts. On the other hand, tort can be resolved by a lawsuit for unpaid damages because it results from a duty owed to all the people. Now let's come to the origin of tort law in Britain. Prior to the invasion of England by William the Conqueror in 1066, the legal system in that country was a bit disorganized and mostly case by case. Post 1066, distinguished judges were sent to tour designated areas in order to take in the local rules that had evolved over a 2-century period. With the aid of this knowledge, these judges studied and applied the principles to their own court rulings that they thought were the most reasonable. Now, what did this lead to? This led to the evolution of precedents with the prolonged use of such practice. Assizes, or sittings in modern parlance, was the term used for the judicial proceedings that were conducted then. Even today, the bench is the location from which a judge issues rulings and sentencing. The phrase common law originated from the idea that equality is the essence of the application of such laws, from the common man to the highest lord of the county. Becket claims that Henry II, the great grandson of William the Conqueror, established a law in 1166, a century post-Norman conquest, under which a panel of 12 men in each county would be chosen to determine the veracity of the allegation of commission of crime as well as the nature and severity of the defendant's punishment. Now the defendants then looked for a less firm path when the common law developed a robust mechanism. Being a member of the clergy, at least in name, was one method to get around the strict rules of common law. The phrase benefit of clergy owes its origin to this practice. The ecclesiastical courts, which are renowned for providing a softer, more humanitarian framework, could hear cases involving those qualified for its protection. It should come as no surprise that this increased the desire to become a clergyman, especially since anyone could do it if he could recite loudly the easily memorized verse 1 of Psalm 51. Have mercy on me, O God, according to your unfailing love. According to your great compassion, blot out my transgressions. This is Psalm 51, 1, King Henry II. Now, after hearing this, became angry by this abuse of his regal authority. After learning of this means of evading justice, it appears that Thomas Becket's perceived treachery was the source of a significant portion of his rage. His elevation from a chancellor to Canterbury's archbishop was a move by Henry II. But it's unclear if he ever imagined his buddy and ostensibly steadfast ally could turn into a rival on any level. Now coming on to the courts of chancery. Becket's courts would initially be known as courts of chancery, subsequently as courts of equity, and finally civil courts. During this early separation of church and state, Henry II was enraged, but Becket remained adamant that any suit involving even a notional cleric had the right to be heard in his ecclesiastical tribunals. The fact that common law courts could only award monetary damages was another reason to file a claim in chancery courts. This meant that the gardener could only be compensated financially if a neighbor's horse was consistently trampling through a rose garden. His emotional grief and frustration over the devastation of his garden were not covered by common law. Additionally, chancery courts had the authority to penalize a wrongdoer from any untoward act of the plaintiff. Thus, the law of equity was intended to establish a setting wherein both emotional suffering and monetary loss were taken into account when rendering a decision. Additionally, rather than the customary language of Latin, cases made before courts of equity were handled in the English language. This meant that everyone involved in this verbal fencing match could understand the words said and read them aloud in an equity court. It has been occasionally said that equity law is a gloss on common law. This definition came to light in particular when a court of equity delivered a judgment that was at odds with one from a common law court. The struggle between the monarch and the archbishop grew more heated. Thus, despite Becket finding some solace in the French court, this conflict continued to divide England. Becket's return to England left no room for negotiation, and Henry II is thought to have asked his barons to kill Becket in the following oft-quoted request: "Will no one rid me of this meddlesome priest?" 4 barons, acting on what they believed to be their monarch's command, soon found and killed Thomas Becket. Shortly thereafter, the king, seen as the impetus of this crime, was subjected to hostility, edging towards hatred. Ultimately, by way of appeasement, King Henry II felt impelled to undergo a public whipping by way of a penance. Additionally, as is often the case with exemplars, Becket's murder gave rise to much more influence than he ever would have if he had passed away suddenly and innocently. Soon after his passing, the Pope had him declared as a saint, giving him the name of Saint Thomas the Martyr. Numerous shrines were constructed in his honor, and Becket's kindness and grace were credited with numerous healings. Initially, much like in common law, the beliefs and morals of a specific chancellor were considered while making judgments by the courts of equity. But eventually, this moral decision was made in favor of the creation of a systematic set of fair rules. Regulations and ideologies took on a defined form. He who enters into equity must have clean hands, which means that if he wants equitable assistance, he must be able to demonstrate to the satisfaction of the court that he acted morally in his intentions with the defendant. This is one of the maxims that the Court of Equity created to express its own ideas. Delay defeats equity refers to the principle that if a claim is brought too late, it will no longer be viable. This is known as the statute of limitations in modern parlance. Now, coming on to the similarity between act and intent. The distinction between actual act of the defendant and his motivations for doing it is the main line dividing laws from the previous from laws currently. At first, only acts were taken into account. The idea of no trial, according to Chief Justice Bryan, because the devil does not know the thought of man. The identities of the parties and judges in many early instances were either not noted or are no longer known. In a 1146 case, a judge ruled that if any individual engages in an act, however right in itself, which may have an effect on others, he has the responsibility to carry out this act to the best of his capacity in an approach which causes no bodily harm or destruction of possessions. This case highlighted the perception of the results of an act rather than whatever intent may have sparked it. To put it in simpler words, the judge explained, if in the process of lifting timber in order to construct a building, I drop a piece of that timber, causing harm to my neighbor's home, he will have a valid claim against me. It will not matter that my construction was entirely lawful or that I did not intend the result to occur. Therefore, logically, the defendant gives the plaintiff both the expense of the labor required to restore the damage and the necessary financial reimbursement. Now, what is the significance of intention? Although first in a tentative manner and with a lingering sense of ambiguity, the significance of intent began to be understood. The intent of the actor is less important to the law than the harm and loss experienced by the other party. This demonstrates that intent had started to be recognized as a force that, while not yet its core, was unable to be further disregarded as being of the tiniest importance. In almost every case, the court must consider the party's purpose both in the criminal and tort systems. If the falling of that timber can be proven to have been done on purpose or with great carelessness, severe penalties may also be awarded in addition to monetary compensation. Compensatory damages, as their words suggest, are intended to compel the party responsible to reimburse the plaintiff for the actual harm, such as replacing a roof or several broken windows. Penalties, on the other hand, are meant to penalize when a judge or jury determines that there was intent or carelessness that bordered on the objective. Nowadays, judges decide the majority of tort matters unless they are particularly serious and call for a jury. Coming precisely to the development of tort law in England, the tort system was developed in England and transmitted to India through England. As already mentioned, following the Norman conquest, French replaced English as the official language of the court. As a result, many specialized terms in English law, including the word tort, have French roots. The idea that everyone in society has certain rights is the foundation of the word tort. And the goal of this law is to uphold those rights and obligations. Writs, which are used to start a legal action, were the various kinds of action that emerged during this period. Real acts and private actions were the two categories into which the types of action were classified. While private acts were used for obtaining compensation for wrongs committed by an individual against another, real actions were used to reclaim territory or other types of property. The 19th century marks the beginning of the development of tort law in England. Now let's take, for instance, the negligence tort, which puts culpability on an individual who failed to act cautiously, but only if this person owes the other individual an obligation of diligence. Only then it leads to the creation of a significant and a prevalent type of tort. This latter component is the most defining aspect of English tort law, and it continues to be a significant barrier to culpability in many tort law areas. Now the term negligence first appears in writs of trespass in the 14th century to describe what? Careless behavior. Now, there are several cases, such as Coke versus Durant, 1377, the calendar of plea, and memoranda rolls. There was no mention of an undertaking, but according to London tradition, everyone had to maintain their fires safe to prevent harm to their neighbors. Keep in mind that the word neighbor is used. It has particular significance in the negligence tort. Let's take another instance of a case law, Beale versus Fingham, 1401, cited by Baker and Milson in the sources of English legal history. Now, the first mention of real custom, the word custom is used, and it should be noted that concepts of custom, tradition, and precedent are all crucial to common law theory and application. The most important tort of the 20th and 21st centuries is negligence. Now, what is negligent behavior? Negligent behavior also refers to actions that make one liable for other crimes. Although the statute is crucial, the tort is mainly a common law subject that judges have established in court, frequently in accordance with societal, financial, and cultural norms. The words "some common law judges" deserve mention here. Now, Lord Stain in Chester versus Afshar, a case of 2004 of United Kingdom House of Lords, said, "The result is in accord with one of the most basic aspirations of the law." And what is that aspiration? Namely, to right wrongs. Moreover, the decision reflects the reasonable expectations of the public in contemporary society. Now, Justice MacDonald in Nova Mink versus Trans-Canada Airlines, a case of 1951, said, "There is always a large element of judicial policy and social expediency involved in the determination of the duty problem. However, it may be obscured by the traditional formulae." According to Lord Mansfield, the reason and spirit of cases make law, not the letter of particular precedent, as per the judgment of Fisher versus Prince of 1764. Matters of practice are not to be known from books. What passes at a judge's chambers is a matter of tradition. It rests in memory, as per the judgment of R versus Wilkes. Whenever the courts draw a line to mark out the bounds of duty, they do it as a matter of policy so as to limit the responsibility of the defendant. This is according to Lord Denning in the case of Spartan Steel versus Martin and Company. Now, moving on further, let's come on to the development of tort law through case laws in England. Now, it is extremely challenging to point to specific examples of legal growth as representations of just one aspect at play. But the discussion's overarching theme is to progress from more straightforward examples to more intricate and nuanced ones. When a chance to start over is consciously passed up, the restricting power of history is most evident. In Shelfer versus City of London Electric Lighting Company, the Court of Appeal established rules for how courts should utilize their discretion to impose damages instead of an injunction in circumstances involving nuisances. The Chancery Amendment Act of 1858, also known as Lord Cairns Act, a relatively new statute, had granted this discretion, but the Court of Appeal refrained from pioneering. The Court of Appeal characterized the circumstances under which it might award damages in place of a prohibition very strictly, drawing heavily on historical presumptions concerning the role of the Court of Chancery in nuisance cases using a simple rule. As a general guideline, it can be said that if an injunction would be oppressive to the defendant and the damage to the claimant's legal rights is minimal, which can be quantified in monetary terms, can be adequately compensated by a small monetary payment, as well as quantified. Damages may be awarded instead of an injunction. The court's determination to limit the potential use of the discretion is clear from the prominence of and matching emphasis on the combinations at the beginning of several considerations. The Shelfer case also exemplifies the power of history in another way, since despite the Court of Appeal's initial claim that it was only providing subsequent courts with a good working rule, its recommendations swiftly took on the appearance of a requirement. Courts in the 20th century used the Shelfer criterion in an increasingly fundamentalist manner, which ultimately led the Supreme Court to call for restraint. A mandatory requirement had been added to what had been described as a broad legislative flexibility. Coming to another case, Barnard versus Perriman. The significance of Barnard versus Perriman's origins and durability is obvious. The story also demonstrates the value of categorization, though, because the Court of Appeal drew on something that could influence and guide other facets of tort relief when it cited the public interest to justify its finding. For instance, it may have been believed that the threat of illimitable, unpredictably high damages awards could deter prospective libel defendants from publishing, which undoubtedly implied a role for concepts of the public interest in the way damages were calculated. This is not implied in the Court of Appeal's ruling in Barnard versus Perriman or in the subsequent instances where the Barnard rule was used. The significance of the public interest also doesn't appear to have altered how restraining orders for other torts are handled. It would not be until the 1970s, in an approach that was purposefully intended to break with tradition, that Lord Denning would take up the issue of the public interest in such circumstances. It appears that no one was immediately worried by the lack of a public interest criterion in the Shelfer formula. This type of highly dispersed legal growth is only feasible if the differences between groups are viewed as so robust and unavoidable and even inevitable that attempts to compare or contrast are immediately rendered invalid. The logical outcome of adhering to the inevitable and simplicity of categorization and distinctions is that analogies or differences between tort and other methods of correction are absolutely unnecessary and can be ignored at the most profound degree of abstraction. This stance is especially evident in the development and functioning of the laborers' compensation system, which, despite having clear overlaps with tort law in terms of objectives, had little to do, no impact on tort concepts. It wasn't as though the tort remedies had not been taken into account when designing the compensation system. The very restricted access to legal damages for workplace injuries, on the other hand, was what gave rise to the compensation system's justification. Now, after a discussion on the history of development of torts, we can say the law of tort remedies was generally resistant to alter. Why? Because of the strong historical influence, conventional legal categories, and a logical dedication to recompense. Legislative efforts have often affirmed and strengthened the fundamental model rather than challenged it, with more extreme suggestions never making onto the statute book. The shortcomings of those bolder ideas serve as practical examples of the political objectives and special interests at play in this area, and draw attention to some stunningly successful lobbying. The notable exception to this rule was Lord Devlin's statement in Rooks versus Barnard. Attempts at dramatic legal reform have also a tendency to stumble, and academic writing appears to have had less of an impact than in the other fields. The mapping of the functions of history, categories, and rationalism is educational, interesting, and occasionally even entertaining. But in order to comprehend why these elements and principles were so significant, as a student of law, students, you must all inevitably look beyond the law of torts and engage in discussions about how the legal systems function generally, as well as the interests, attitudes, and the presumptions of its most prominent members. With this, we come to the end of today's lecture. Thank you very much.